Start.
All right. Okay, well, good afternoon, everyone. We're glad to have you here for today's CLE jury trial versus bench trial versus court annexed arbitration. For those of you who registered, you will be receiving 1 hour of CLE credit. I'm Smith Spencer, and I have the pleasure of moderating today's presentation. We have a very distinguished panel of judges today with us for discussion. I want to thank them for taking the time to speak with us and share their thoughts and observations on this topic. I'd like to introduce first, we have Judge Maria Barlow, who presides in courtroom 1102. Judge Aileen Bandari presides in courtroom 1106. Judge Carrie Maloney Layton presides in courtroom 1503. Judge Perlette Tirado, who presides in courtroom 1403. And Judge Alon Stein, the supervising judge in 1501. Judge Stein is also a former arbitrator for court annexed arbitration. So today's discussion is going to be focusing on these different forums for presenting your case and suggestions and practice tips that are unique to each. And because each of these audiences is different, it's important that as attorneys that we tailor our preparation and our presentation to each. So I'd like to start out by discussing bench trials and asking Judge Bandari and Judge Barlow if they have any thoughts or comments on what are some considerations that are unique to the bench trial. Oh, Judge Bandari, you're muted.
All right, thank you for that. If Judge Barlow wants to go, that's fine. If not, I think uniquely for the bench trials, for our courtroom, I think is sometimes making sure your witnesses are prepped. I think that's an important aspect of it, and making sure they know what to expect and how to, I suppose, answer the questions that are asked of them. I think sometimes I see a lot of witnesses on the stand and they kind of want to go off into a tangent. They want to give all the information at once. But I think importantly, it's important to prep your witnesses. But we do deal with a lot of litigants in our courtrooms that are pro se. So sometimes there's a unique challenge of having one litigant who has an attorney versus a pro se litigant. And those present unique challenges for our courtrooms because a lot of pro se litigants, are obviously they're not attorneys and they're in unique positions in terms of how are they going to present their evidence, cross-examination questions, and things like that. But I think those are some of the unique things that we see in our bench trials. And I'm sure there's pro se litigants in jury trials as well. But definitely making sure the witnesses are prepped ahead of time for these trials is something that needs to be done ahead of time.
Judge Barlow, did you have anything to add to that? Something things that are unique considerations for the bench trials?
And typically, especially in my room, if there is a small claim, and I don't know if the jury room judges do it, I typically on the court sum motion relax the rules of evidence. And I think that's somewhat consistent with a lot of us. And I think that sometimes it's a little bit difficult for attorneys because they're ready. They want to give a big opening. They want to give a big closing. And it's just a little more relaxed. I know sometimes they want to make their objections regarding evidence. And so, all relevant evidence is admissible for a small claim. And so I try to explain it both to the litigants and the attorneys at the very onset of the case, kind of how we're going to do this process in an informal type of way. And I think it becomes a little bit difficult to a trained attorney to not go directly into that training that they've always learned about how to put this trial on, how to admit this evidence and do things like that. But it's just something they should consider, especially when you're in a bench trial. The other thing I would say is important with the closing arguments. I just sat through the evidence, right? So I don't need as big of a presentation as a jury judge or as a jury. I've heard it. I know the law, so you can hear your highlights and we can get to the ruling. It's not, necessarily as big of a presentation required for a bench trial as a jury, because I'm the same person that's going to decide it, and I've sat here and I've heard the evidence.
I would like to jump off on that. That is, that's a very good point. Where I had a trial the other day, and they asked a bunch of questions, and then the next question, the attorney's like, "So to reiterate," and I was like, "No, no, there's no need to reiterate. I have heard, I have listened to everything." And sometimes one of the things I say to the attorneys, like, "It's just me." Like, so we don't have to have, it doesn't have to be a whole show. It's just me. I've heard it. I'm paying attention. And some of the things that are unique, especially for a jury trial where you're trying to get the attention of 12 people, making sure everyone heard the evidence and the witness's words, and making sure it's explained properly, and asking a question a different way just to make sure the jury gets it. I think uniquely for judges, I think is a little bit different. You don't have to go through all of that. It can actually, you can get to the heart of the issue much faster, I think, in a bench trial than you have to in a jury trial, because you can really just get to the issue of it. A lot of times in a bench trial, when the attorneys come before me, I'll ask them to agree upon the exhibits, so that and that there's a stipulation that the foundations have been laid and these exhibits will all be admitted, especially if they both have binders, so that we don't have to take the time to go through each exhibit and lay the foundation. If you guys are going to agree that this is a contract and this is the invoices and that they're going to be admitted, let's just do that up front. And I think that's uniquely, you really can't, sometimes you can do that, but in the presence of a jury, you kind of need to have some of that done in front of a jury, because the jury is paying attention and making that decision.
And Judge Barlow, you mentioned, objections during a bench trial. Should attorneys still be prepared to make objections, or should they trust that the judge will know what should be considered and what should?
So if it's a small claim, there's not a whole lot of objections to be made, right? It's a small claim. The rules say it's informal. The rules say all relevant evidence gets admitted. And so sometimes I find that attorneys object to foundation and things like that, which they're not required to do. If there is a proper objection, they should absolutely make it. And again, I'm talking mostly about small claims. If there's a proper objection, absolutely make it. I'm not going to make it for you. And you can't make it late and say, Judge, the last 10 minutes have been hearsay. Counsel, what do you want me to do? But typically, if it's a small claim and a self-represented litigant, I'll typically tell them, okay, wait, you are telling me things that happen outside of court. It's hearsay. It's not admissible. You can only tell me what you hear, what you heard, what you saw, what you know personally. And so I will redirect them even if there's not an objection, because I know that attorneys sometimes feel like, okay, I don't know how far to let this litigant go, the judges. So I typically will redirect them to what they need to talk about and what they can tell me and what I can consider.
Thank you. So I'd like to move on and talk to the judges who do the jury trials in municipal, Judge Maloney-Layton and Judge Tirado. From a court's perspective, can you tell us what does it really mean for a case to be, trial ready, and what problems arise when it's not?
I can go first if that's fine. So I would say for me, when a case is truly trial ready, is that all discovery issues have been addressed. It's happened more often than I would like for it to happen in my courtroom, where we're on the eve of trial, pre-trial, and suddenly attorneys are filing motions to bar. And I think those are things that should be addressed well in advance, at least for me personally, because a lot of times it's issues that were already known well in advance. I don't know why attorneys sometimes wait for, the day before trial. But from my perspective, I think that that's an issue that attorneys would want resolved, because then that sets the tone for how you're going to prepare the rest of your trial, witnesses, exhibits, and you're not throwing everything together last minute. Also, I would say that witnesses are prepped, that you know what testimony you're trying to get from every witness. I don't know if a lot of the times the attorneys are meeting their witness for the first time at trial, but it is clear sometimes when a witness has not been fully prepped. aside from being nervous and knowing that there's, 6, 12 people looking at them, I mean, I know everyone gets nervous. But I would say that witness preparation is definitely important as well. And I would also say that having all your jury instructions, motions in limine ready as well. It causes major delays when we're still sorting through jury instructions the day of trial, especially if we've already discussed them the day before. And I'd say the final thing that's important that tells me that the case is ready to go as well are the evidence depositions that, attorneys have properly addressed all objections, that, we're not still shuffling through deposition while the jury's waiting outside. That, a lot of times when I do receive pretrial materials, I'll get the jury instructions, look at the motions in limine, and I'm like, okay, well, are there any evidence depositions? Then I'll have to email the attorneys and ask, and they're like, oh yeah, sorry, we forgot to send them. And I think those are the things that cause major delays, because I think when a case is ready to go to trial, you walk in the courtroom and it's just a matter of saying, okay, we're going to call the jury and have them brought down. So I would say those are the things that, for me, make the difference as to whether something's truly trial ready or not.
Judge Maloney-Layton, kind of going on from that, could you tell us some of the basic, lawyering mistakes that you have seen in your courtroom that, may have been easily avoided with, better preparation?
Yeah, I mean, just to build on what Judge Tirado was saying, I would second all of those points. But I think the key takeaway from what she's saying is be prepared in advance. So don't be looking at your case for the first time the Friday before you're supposed to have your pretrial on the Monday, and then realizing, oh, shoot, I've never talked to my witness, or there were these materials that I really need to put together. I mean, it's a little different with a jury trial because in our jury rooms, we only have so many jurors that we call into the Daly Center every day. And so we have a lot of different jury rooms competing for that set of jurors. And so in order to be able to go to a jury trial on the day in question, you have to be ready to go in the morning. And so I always set a pretrial in advance, a day or two before. I know a lot of other jury judges do as well. And so what we really need is for you to be prepared for that pretrial so that we can get through the motions in limine. We can make sure we have the correct jury instructions, for your case. I go through the jury instructions at the pretrial, and there's so many times when I'm like, oh, what about this instruction? Somebody's left it out. If we were doing that the morning of, how are you going to get that printed? How are you going to get copies to me? There's paper that needs to be generated that you have to bring into court with you in person, on the day in question. And so if we're sitting there sorting through those issues, time is ticking and we begin to run out of jurors. And it has happened to me more than once that we get, once we get everything resolved, oh, there's only 5 jurors left in the jury room. And so you've spent all this time, you've shown up to court, your witnesses have shown up to court, and we can't go forward with your trial. So to avoid those problems, we all need to work together. Get ready for your pretrial plan, that make sure your witness is going to be available on the trial day well in advance. Because if you need to file a motion to continue the trial, that needs to be on file for us to consider. And the rule requires you to file an affidavit that states the basis for it. And there's so much casualness with respect to this practice where people walk in and like, oh, Judge, I couldn't reach so-and-so. Can we just kick the trial? No, we can't. And there's important reasons for that. We need to preserve a record about what happens in our cases. Even though we're first municipal and we're under 50,000 or, smaller claims, that doesn't mean we're a less serious court. And I think sometimes people forget that. And, You would never do this kind of practice if you were in the appellate court or you were in the Supreme Court or the US Supreme Court, where you would just casually ask somebody to kick your trial. You have to preserve the record by filing your documents in the record. You have to be prepared when you come in, to discuss those things. I have so many times when I have doing a pretrial and that attorney is looking at the other side's motions in limine for the first time as we speak. That's a waste of people's time. That's not fair. I could go on, but I won't.
If I can also add one more thing based on what Judge Maloney-Layden said as well, is I think what would also be really helpful, if you know that a case is going to trial, that you just reach out to opposing counsel and find out, okay, what are the instructions that we agree on? What are the motions in limine that we agree on? So that it makes the pretrial hearing go so much faster when you just say, okay, but these are the issues that are still in dispute, but everything else were agreed upon. And I wonder if a lot of times attorneys even bother reaching out to the other side. I mean, aside from trying to settle the case, I mean, do you have a discussion with the other side to figure out, okay, let's come up with a statement of the case. How many witnesses are you going to have? And to Judge Maloney-Layden's point, I sometimes wonder if when the attorneys are before me, is that the first time that they've actually talked about the case from the time that it was first up for case management? And I know that attorneys, there's so much you have on your plate every day. There's so many trials that are set and you're trying to figure out which ones are going. But it almost seems like that one case that you thought wasn't going to trial is the one that ends up going to trial. And so I think that you work the case up so that you show up the day of intake. Okay, don't just put it aside and then pick it up a week before it's going to trial, but regularly look it over so that you're updating information. Because I do think that a lot of the delays could be avoided if the case were nurtured from from before it actually gets to trial.
So to follow up on that, in terms of communication with the other side, do either of you, Judge Maloney-Layden or Judge Tirado, do you have a standing order or any type of requirement that the parties exchange motions in limine before the pretrial, or if not, do you think that would be a good practice?
I can speak to this. I have a standing order. It's on the court's website. It does require you to get those materials that we were talking about, the motions in limine, the evidence step transcripts, the jury instructions together in advance to get to me and, of course, to opposing counsel. But it's just good practice. I don't think that you need a standing order to require you to, as Judge Tirado is saying, consult with opposing counsel. This case is really going to trial. We're trying to settle, but we weren't able to settle. So we need to get this together so that we can be prepared. And it definitely helps if both sides are working together.
Thank you. So moving on from the bench trials and the jury trials, we also have the court annexed arbitration. And Judge Stein, can you tell me, are there anything, is there anything, specific in terms of preparation or lack thereof that you think would be important to mention regarding arbitration hearings? I know we have more relaxed rules of evidence, but still, do you have anything in particular that you would like to highlight for attorneys?
Yeah, and I'm going to give it from the perspective of the judge in 1501. Plus, I was an attorney who did arbitrations, and I was also an arbitrator. So I would prepare for an arbitration like a jury trial, but without jury instructions. But we want the brevity of a bench trial. I mean, that's how I would do it. But take it seriously. Don't expect the arbitrators to read your 90C packet from cover to cover. Usually you walk into the arbitration center, there are 3 arbitrators, a chairperson, and 2, one to the left, one to the right. You get handed a stack of documents, and you have a very limited time to digest that information as an arbitrator. Having done lots and lots of arbitrations, I've yet to see an arbitrator, except for me, of course, I did that all the time, comb through the packet from cover to cover. It's very important that when you're there, that you have a very good presentation, that your witnesses are prepared. So you got to spend time prepping the witnesses. I don't know how many times I was an arbitrator, I would see arbitrations where the witnesses were completely not prepared. Know the Supreme Court rules 86 to 95 inside and out. And that's your Bible. And if it's a law division arbitration, make sure that you know Supreme Court Rule 25, which doesn't apply for the mandatory arbitration. Be organized, be concise. When you're presenting the case as a plaintiff's counsel, make sure that you ask the arbitrators exactly what you want. So say, I want you to award us this. Don't make the arbitrators do math. It's not a good idea. And if you're on the defense, you say, I want an award in favor of defendant. Or you say, I want a reduced amount. If you were to find the plaintiff is successful on something, give us a reduced amount and say, I want an award in the amount of this. Again, don't make the arbitrators do math. Finally, make sure everybody shows up. I don't know how many times there's witnesses that don't show up, especially if there's a Rule 237 notice. Those are taken very seriously on motions to debar. Finally, tell your clients that the arbitration is at 222 North LaSalle. It's not in courtroom 1501. I don't know how many times I'd be sitting in 1501 and people are sitting in the courtroom thinking that there's going to be an arbitration. No, it's the arbitration's at the arbitration center, not at the Daly Center.
So you mentioned that, it's important that the attorneys, ask the arbitration panel, for an award in their client's favor, or in the alternative, a different amount. Would you say that it's a good practice to, suggest an alternative amount if in fact the arbitrators don't find in your favor if you're a defendant?
Yes. And I would say that if you're a plaintiff, it's really important to have a cover sheet on your 90C packet that designates paid versus unpaid and itemizing the damages. Also, it's really important to have not leave out relevant materials, because everything that's in the 90C packet that's appropriate is presumed to be admissible. We have very relaxed standards in arbitration, and it's really important that anything that you want to have admitted be put in that 90C packet. Finally, you should also ask for costs. I don't know how many times people don't ask for costs, and that's supposed to be requested. One last thing, make sure it's paginated. When you have a giant 90C packet and you're referring to things, it's really important to say on page 23, take a look at this versus just it's somewhere in there.
What if, Judge Stein, what if I get a 90C packet from, either the plaintiff or defendant's counsel, and we'll assume it's timely, we'll assume it's paginated, we'll assume it's got the right cover page, but what if it has something in there that I don't believe, is in accordance with the rules? For example, a police report, and I see this, it's not the day of the arbitration, I have some time. What remedy do I have, if any?
An arbitrator and the chairperson is not allowed to rule on any motions. All motions need to be brought in courtroom 1501. So what you need to do is you need to file a motion in courtroom 1501. You'll be one of my, 70 motions a day. And if you do it at the last minute, you could file it as an emergency motion at 9 o'clock the day of. Not the way to do it, not the best way to do it, but I see it done all the time.
Thank
But
you.
you've got to bring it in courtroom 1501. You cannot bring a motion in front of an arbitrator. Even if the arbitrator has 50 years of experience, that arbitrator is not allowed to rule on motions.
Thank you. And we were talking earlier about jury instructions with the jury trials, but I was just wondering, as far as the bench trials, Judges Bhandari and Barlow, do you see any utility in, an attorney utilizing or looking at jury instructions in preparation for his or her case in a bench trial?
I think it's always helpful. I mean, the jury instructions give you a basis as what the allegations are, what you have to prove. And it's the same whether you're in front of a bench, in front of a judge or a jury. So on your own, you definitely can use that. You can use that to help you with your closing arguments or even making your opening statement, or to help you direct how you're going to present your evidence, what your burden of proof is. So I think looking to the jury instructions on a particular issue probably helps even when drafting your complaint, because you need to know what is the elements of your allegation and what you have to prove to a jury. So I think those are informational and instructional for a lot of people, in formulating the complaint and making your arguments or presenting your issues.
So I agree with what Judge Bhandari said, but I'm also a big fan of use all resources available to you to get the point that you're trying to make, to get the judgment that you're trying to get to win the day. Use all resources available to you. And in the day and time that we live now, double check if it's AI, because AI lies. But outside of that, and everyone said it, be prepared. Whatever it is that you think is best to help you be prepared, and be prepared for questions, because sometimes I know I ask questions, especially if I don't understand. I ask a lot of questions. So be prepared, know your facts, know the law and how it applies. For the other side, how it doesn't apply to this case.
Maeve, can I follow up on one point I made before? On the motions, the motion to file is a motion to strike the document from the 90C packet. If you don't do that, you can always object at the arbitration, and the arbitrator can rule on the objections. But the appropriate way to do it is to file a motion to strike the police report from the 90C packet in order to streamline the arbitration.
Thank you. The judges with the jury rooms, talking a lot about preparation. I'd like to ask a question about motions. Do either of you have a preference in terms of motions, whether should they be oral, or do you prefer them in written form? And if you do have a preference, why would that be?
Do you want us to take this, Judge Trotter? I'm happy to take it.
No, you go and I can just fill in, because I think you have a lot of good points on that.
Well, I guess it just goes back to what I was saying before, that, I think sometimes attorneys, a lot of times this, the kinds of cases we hear, maybe it's their first assignment and maybe they aren't that familiar with what happens after these cases get wrapped up. But I think we should treat this municipal practice as like a training ground for best practices, throughout your career, even if you're a new attorney, and not get into the kinds of habits that are not going to fly in other practices and other later, more advanced assignments, so to speak. Because, we operate our courts in the public for a reason. Courts are supposed to be open to the public to observe, and we are supposed to preserve what happened. And we do that by filing documents into our court filing system. And that is what allows the public, attorneys, yourself later to go back and figure out what happened in a particular case. And that's important for the integrity of our proceedings, but it's also important if you should need to take it to a higher level, a higher court. And it is, if something is said orally, especially in our jury rooms where there is no court reporter, no electronic recording, and not indicated necessarily on the order or just casually indicated on an order, it is not preserved in the record. And so if you did need to take an appeal, there's a case that basically says, you know, if it's not in the common law record, it can't be considered, and you are not going to be able to preserve your argument for appeal. But so I think for all those reasons, the integrity of our proceeding, it is best practice so we can look back later, find out what happened in your case, that you have filed something into our court clerk system, our Odyssey system, our docketing system. That's how we maintain, you know, tabs on what's happened in a matter. And then that way you can properly be heard by a judge in the open courtroom, not in the email box, not, you know, walking into court and just talking to the judge off the cuff. There's a lot of confusion that can follow from that kind of practice. Different judges fill in at different times. You don't know what happened if someone walks in and orally there's a ruling on something in that courtroom because the judge is covering, but it never gets entered in the record. We don't know what happened. It's just bad practice, and we should treat this practice as seriously as we treat all other practices. My 2 cents.
Smith, I want to add, as a judge who presides over the civil motion call, I would say that an oral motion isn't worth the paper it isn't written on.
I think that's a good point. And Judge Maloney-Layton, I know you have in your prior life, you have experience in this area in the appellate world, so you know what you're talking about. I appreciate that. Judge Tirado, kind of building on that, when it comes to preserving issues for appeal in a trial, what do attorneys tend to miss? What do you see in your experience?
Okay. Well, I did want to go back a little bit to what Carrie said. So every judge is different, and we know that it's, if you know, you think, okay, I'm going to do it this way because I did it like this way with the other judge, and then you walk into court and then the judge is like, no, actually, I want you to do it this way. So I know it can be very frustrating and confusing sometimes for attorneys when judges have different expectations of how to do things. So I think that the easiest thing to do is just ask the judge, how do you handle this if you're in doubt? You know, and I like it when attorneys ask me questions to clarify things, because then that way we're on the same page and you know how I want things done. I would say that when it is a housekeeping matter, for example, I don't know, I can't think of anything, but it's something that, you know, opposing counsel is not going to oppose and there's an agreement. I'm fine with an oral motion so long as the order then reflects what was discussed in court, that it's not just a one-line motion granted, but that you actually write, you know, what was discussed in court. I'm fine with that. Substantive motions, yes, definitely have to be in writing because like Judge Maloney-Layton said, you're making the record. So unless you have a court reporter in court, you definitely want to have the record preserved. When filing your motions, I think, at least for me, more details, more information is better than not providing enough information. Everyone that practices in my courtroom knows that I will almost always issue a written ruling when a motion comes before me, because I like taking time to think about it. And, you know, I read everything. I read everything that attorneys submit. I'll write notes. And then, you know, after oral arguments, I, you know, come back to my office and I review everything, review my notes. And then I just sit there and I start, you know, trying to put everything together. What I think is really helpful that is sometimes lacking is not providing a clear, organized argument of what it is that you're asking for. And also providing case law to back up your argument. Because I think a lot of times it's just, you know, a free flow of thoughts, arguments, but there's you know, no support for whatever it is that you're asking for. And so then I'm like, okay, well, now I have to start, like, do I start doing research? Am I suddenly now, you know, law clerk here trying to figure out what the attorney's trying to say? So I would say, because I mean, obviously I am probably going to do my own research, but attorneys should almost always submit case law, cite to case law when you're writing your motion, even if you think that, if it's an argument or it's a motion that you have filed multiple times in multiple courtrooms. Every judge is different. Every judge is going to look at it in a different way. So I would say that if you have a standard practice of how you prepare your motion, that you make sure that you have, you state the facts. Don't just assume that the judge is going to know, background. I mean, although I do always look at procedural history and I'm always clicking on files, but, at least if you can attach a copy of the complaint, attach affirmative defenses, answers. So as much information as you can give as, as an exhibit attachment would be helpful. But definitely have case law to support your argument and not just, do a free flow and say, okay, and then have me try and figure out what you're trying to say. I don't know if that answered the question, but I know that Judge Maloney Layden and I have had many conversations about this.
Yeah, and I mean, just to follow up on that, I mean, this is lawyering 101, and you should, if you're going to bring a motion, what standard is the judge going to consider this motion under? You should cite what the elements are that the judge needs to understand to rule in your favor, and you should cite the relevant facts and the relevant case law to support your position. But so many motions I see are a stream of consciousness, off the cuff, and I'll have to ask oral argument, well, what's the standard if I want to grant a motion to reconsider? What would I need? What would you need to show me? And sometimes they don't know. Sometimes lawyers don't know. So like, do your basic preparation in advance.
Thank you. In terms of, preserving the record, kind of going on from that, making objections during a trial. What is the best way for us, for we as attorneys to make objections during a trial, but without interrupting, the flow of the trial?
I think, I mean, maybe for juries, it's obviously it's a little bit different. You have a jury there. You're really supposed to argue some of those things outside the presence of the jury. But I think definitely in a bench trial, you should make the objection, if the question is a bad, the form of the question, whatever it is. Sometimes, can say objection. Sometimes I will ask for a basis, like what is the basis of your objection? And I think that attorneys should be prepared to, have the basis because sometimes, not always, we do have a court reporter for our bench trials. And I really try to make sure that there is a record, especially when we have a court reporter. The formality kind of goes up a notch. So when objections are being made, I think there should be the basis of it. What's your reasoning for it? And because if I make a ruling on it on that basis alone and it goes up on appeal, there is a record of it. And I think that you have to sometimes interrupt, especially if it's a form of the question or whatever it is. But I think for juries, the judges have their own way of how they would like the objections or what they may want you to say objection and state a very small basis and then a sidebar to discuss it further. But certainly in a bench trial, you can make your objections, and sometimes I let them go back and forth before I make a ruling. But I try to hear the basis, what the other side has to say, and then I'll give you my ruling. But I think you can't not interrupt the trial because you have to make a timely objection, especially when the question is asked or before the answer. Sometimes the answer comes out in front of a jury. You can't unring that bell. So and certainly in front of a judge, I think it's easier for a judge to not listen to, if an answer comes out and not to consider it.
In arbitrations, people should object. The evidentiary admissibility standards are lessened, but the chairperson is the one that generally rules on the objections. Oftentimes it would be, I'll take it for what it's worth, objection overruled. But sometimes, the chairperson will exclude evidence. And so you should raise those objections, and if sometimes they might disrupt the flow of things, but you got to preserve your objections. And oftentimes there is a court reporter there. So.
So I know the ARB Center doesn't, provide court reporters, but attorneys are allowed to, hire their own court reporter and have them there for the proceedings, right?
Right, and oftentimes it's actually used as a discovery tool. And it's because we're not arguing over a whole lot of money in these first municipal cases. Oftentimes, either the plaintiff or the defendant or both bring a court reporter there, and they use it as an inexpensive deposition of the witnesses.
I wanted to ask you, Judge Stein, I've had the opportunity to bring a number of motions in front of you asking for permission to have my clients testify or have witnesses testify at the arbitration hearing remotely, either by Zoom or telephone. And I'm wondering if you have any suggestions for best practice, if such a motion is granted, how best to prepare your witnesses for remote testimony.
First of all, they should show up. So I don't know how many times when I was at arbitration, you would call the person, they wouldn't answer the phone. So tell them be here at this time and pick up the phone. The best practice is learn how to use your device. Telephone testimony is probably one of the worst types of testimony you could have on the cell phone. Oftentimes you hear every other word. If you do have a court reporter trying to create a record, it's impossible to do that when the court reporter can't hear you. Tell them to talk slowly and clearly, and listen to the question, answer the question, and stop talking. And then I would say the best way to do it, remote testimony, is either through an iPad or Zoom with the lawyer to supply the testimony. And it's just be concise and answer the question. Tell the truth.
Judges Barlow and Bandari, in terms of the trials that you have in your courtrooms, do you allow for remote testimony under any circumstances?
I typically don't. There has to be some limited, usually if there's an objection, or it has to be a very good reason why your client or your witness can't be here. I've also had occasion where I have allowed it because it's two self-represented litigants, and they really feel that this person's presence can help, but it's typically a very limited circumstance that I allow remote testimony.
I typically, part of the admonishments I give especially to the pro se litigants, is that sometimes I try to send them to mediation, and if you can't work it out, it will be an in-person trial. And so that require, I don't know where they're coming from, or they're like, oh, if you don't settle, you have to come in person, and we do require that because I know that we have done trials in the past on Zoom, but I feel like sometimes with the evidence that they have, the receipts, things that they have that they want to show you, it's very difficult for them to navigate on Zoom, to share screens, and for the other side to see what they have. And if they're not able to manage exchanging those exhibits ahead of time, and then you're doing a trial, it really behooves having it on Zoom. So I do try to require that they come in person and exchange their documents 7 days or whatnot ahead of time. However, there's always an exception. If there is a medical issue, if there's a health issue, there's a traveling issue. And sometimes if there is an issue where it's not really an issue of evidence, sort of where two sides really just have to tell the story, whether they paid for the vest or not, and they got the vest, and whether they're entitled to their money back. It is something that you can kind of do on Zoom. So most often they should be here in person, but I will make an exception, especially if there's a good enough reason for it.
Part of mine also is determined by your behavior on Zoom. I pay attention to my cases, and sometimes, don't say this, say that. You definitely don't qualify for a Zoom testimony sort of situation. You are definitely an in-person sort of case. So it's what Judge Bandari said, and also sometimes your behavior on Zoom.
Okay, thank you. I'd like to I'd ask that question of the jury courtrooms as well, Judge Maloney Layton and Judge Tirado. Do you have anything in your standing orders, or what's your policy regarding remote testimony at proceedings?
So I can start out with this. So I don't have a standing order. We're actually in the process of trying to have a uniform standing order for all the jury rooms that we have to work on. But my take on it, my first question will be if someone says, the medical biller, is in Florida and they can't come in. My first question will be, well, have you talked to opposing counsel? Is there any objection or is this by agreement? And so I think to me, that's the most important thing. Have you reached out to opposing counsel? Because if they're fine with it, then I'm probably going to go along with it too, so long as, there's a valid reason for why the person can't be here. But I would also say that let me know the minute it's going to become an issue. Don't wait for the day of trial and say, oh yeah, so my witness can't be here, because more than likely it's going to get denied. So if you know ahead of time, let me know. And the attorneys who practice before me know that too, that I'm flexible so long as you let me know of what problems you anticipate coming up, and also reach out to opposing counsel. And if there is no objection or they're fine with it, like I said, unless it's something completely outrageous, then I will almost always go along with it, so long as, one, you let me know once it becomes a problem, and two, if you reached out to opposing counsel and you have a solution proposed when you come to me.
And I would just add, there's a rule for this, Illinois Supreme Court Rule 241. You should take a look at it and file the appropriate motion in writing. There's good cause shown, so that's a requirement if you're going to have testimonial remote participation. And so you need to meet a standard. It can't just be, oh, my witness, forgot or whatever. Like that, you have to meet a standard. Again, know the standard that applies, file the motion, bring it in advance. And there are ways that we can have witnesses testify remotely, even in front of a jury, although it is less than ideal, probably for your presentation. In a lot of our cases, though, especially the smaller dollar jury trials, the way people handle that is doing the evidence step route, where you can take the evidence step in advance and then have those transcripts ready. The judge can rule on all the objections. It streamlines the process. During trial, you just have someone on the stand reading the agreed upon questions, or, the lawyer reads the questions and a witness on the stand acts out the answers. And so that's the way to do it. But meet the standard required for it. And if you do, then it's appropriate. And if not, then it's not.
In terms of witnesses at, either bench trials or jury trials, would any of you say that there's a difference in how we as attorneys should prepare for that testimony, bench versus jury?
I think all the witnesses should be prepared, but I think that for me, like Judge Stein had said, when you're preparing for arbitration, it should kind of the brevity of a bench trial, so that you can prepare your witnesses for the trial, but that you don't have to get into some of the background that you do for a jury, right? To make it longer, because you kind of introduce the witness to the jury, so they get a little background information. And it's okay to do that with a judge. It's probably like 2 or 3 questions, where do you work, where do you live, how long have you known someone? And then let's get to the heart of, did you sign this contract and what happened? So you can kind of get to the heart of it, and have your witness be prepared to answer those types of questions. But I think that preparing the witness is very important. And also I think a lot of them may not be prepared for cross-exam, right? You're prepared to answer the questions that I'm going to ask you on direct, but it's the cross-examination questions. And I think most importantly, and I think whether it's a bench or a jury trial, the trier of fact is always making the determination of somebody's credibility. And if your witness is fighting the answer for a judge or a jury, it really can affect the credibility of your witness, right? If they cannot barely answer, were you standing at the corner? Did you see her? I was at the corner, but did you see her? Well, I was at the corner. Well, and they don't answer the question. It's just like, if the more that you fight and you're not answering something that's so basic or simple, that's not giving any leeway to the actual issue, that as a trier of fact means a lot to me, of how you answer the question and your ability to be forthcoming with answers, even especially if it's detrimental to your case. If someone is more truthful of, did you say something? Did you yell or scream at someone when you gave the answer? Yes, I did that, as opposed to fighting that answer. And a lot of times the witnesses want to somewhat spar on cross-examination with the other attorney. I don't think that's ever a good idea. And I think that the witnesses should be prepared for that, to still treat the other side with respect and answer the question, and not try to, especially the answering back. And then you get witnesses who ask the opposing counsel questions, and we have to give admonishment, like, you don't get to ask questions, they get to ask you questions. And I take that with, it depends on how it's going along, and I get it, people just want to get their sides out, but at some point it can be detrimental to your case if your witness is fighting the answers or sparring with opposing counsel.
Smith, when I prepare my witnesses for both jury trials, bench trials, and for arbitrations, I would use a rule called the LAS rule. Listen to the question, answer to the question, stop talking. LAS. I think that applies for all the situations. Just listen, answer, stop.
And then I would just say, in the jury context, there's nothing worse than the jury feeling like you are wasting their time. And if there has to be so much back and forth to get out basic, simple things, that is not helping your case in front of the jury. They're hungry. They want to go to lunch. They don't understand, if there's all these objections that are being made, he's not answering the question, direct the witness to answer, all the rest. And so it is so counterproductive if your witness isn't prepared to just, as Judge Stein said, listen and answer, and then the rest, F you.
If I can also add one final note there, because this is fresh in my mind, because this was an issue yesterday for one of my juries. If your witness requires an interpreter, let us know ahead of time as well, because that also slows down the question process. And I would say advise all clients, not just those that require an interpreter, but all witnesses, wait till the question is asked before you start answering, because that happens a lot. Okay, you rehearsed it, you went over it, but let me finish asking my question before you start answering, because then I have to interrupt everything to remind the witness, let the attorney finish their question before you start answering. And likewise for the attorneys, let the interpreter finish interpreting before you start moving on to your next question, because that very much annoys and frustrates the jury. You can see it in their face that they're getting frustrated.
Well, that's helpful. I especially appreciate the strong suggestion to prepare your witnesses and prepare them for cross-examination as well. Let them know that that's coming, and perhaps alert them to the fact that they may be asked some questions maybe from that were asked in their deposition or something like that, and the best way for them to respond to that, not to get into it with the other attorney. Building on that, can you tell me, any of you, what issues other than what we just talked about do you see most often during witness examinations, and how can attorneys handle those moments more effectively?
Just one point, coach them that when there's an objection, they need to stop talking and let the attorneys figure it out, because I think more often than not, it happens that they'll just continue talking. And then by that point, is there even a reason to object at this point if they said what they weren't supposed to say? So, when I was practicing and I prep my witnesses, I'd go over the direct, and I would also focus on the cross, but I would always tell them, well, maybe pause for a moment before you start answering. And it's fundamental. If you don't understand the question, ask, can you repeat it? Because we all know this. There's nothing worse than giving the wrong answer to a question that you didn't understand. And from the jury perspective, if you answer a question that you don't understand and they already heard it, too late. the information's out there.
Smith, I think we have some Q&A people from some questions and answers from the audience. And I was wondering if we can maybe open it up to that.
Sure. I think that's a great idea. Let's see.
Who has a question?
Well, I see one question here that's asked, how can we make the judge careful not to take on the role of being the unrepresented litigant's attorney without being antagonistic? And I think that's a great question. I think when you come, so we're talking about pro se people, and for me, we get that a lot. That's a lot of the bench trials that we do. And I would just say to attorneys to be patient. It's their day in court. In my perspective, this is their day in court, and they should have an opportunity to be heard. And sometimes they get to say stuff and things that are not relevant, hearsay. The police told, even if it's a bench trial and they're making these statements, I'm only taking into account what's relevant and what I can take into account. Them saying it is not hurting your case at all. And to have the patience to let them say that. So if you make an objection and I say, counsel, I'm gonna let him talk. It might seem like I'm in their favor or whatnot, but what I'm really doing is, especially in a lot of pro se where they don't have the legal basis and they're kind of already losing, is to give them their day in court so that when I do make my ruling and it's not in their favor, they at least felt like they're heard. So especially unrepresented litigants. And so sometimes it might seem like we're taking on the role. A lot of times, if it's under 10,000, I will do a case pursuant to Supreme Court Rule 286B, where I will do or I'm allowed to ask direct and cross-examination questions. And I think it makes the process go along a little bit faster. But of course, if there's an attorney on the other side, I let them handle their client and their case. I hopefully attorneys will understand that we're not trying to be the litigant's attorney, but we are trying to move the case along and trying to get out the information from the pro se litigant quicker and faster in a concise manner by asking the questions, especially in the 286B hearing, because it's a little bit less informal. And I think that your patience is very much appreciated because without antagonizing the pro se litigants, because they already feel probably like they're that they don't have as much experience, and that they're kind of behind in experience, and that everyone's somewhat against them. They're the small guy in the big courtroom. So I think my role as a judge is to make sure that people feel that they're being heard as a litigant, and then I give careful consideration to all the evidence that's presented to me, and that you fighting with a pro se person, it doesn't really win you any points, because as a judge, especially in a bench trial, we kind of already know what should be deemed admitted and what's not admitted. But I really just try to make sure that they feel like they've had their day in court. And so patience, I think, is very important on both sides of the aisle.
Yeah, and then just to build on that, I think what many lawyers don't understand is that we do have, as judges, as part of our code of ethics or code of conduct, the obligation to facilitate the ability of all parties to present their case. So to the extent it might seem like we're favoring the pro se, obviously we have to hold them to the same standards that we would hold a lawyer to, but at the same time, we're supposed to facilitate their ability to present their case. So there's a balance there, a delicate balance that you have to understand. And I've seen, as Judge Bandari said, attorneys fighting so hard on every evidentiary point with a self-represented litigant who, from our perspective as judges, we know is going to lose. Like they are going to lose. There is no way that when the jury gets the elements that they're supposed to apply, this person is going to have a chance. But it just delays the trial. It makes it contentious. It makes it uncomfortable. Sometimes, just roll with it a little. Let the pro se person, ask a question that's not relevant or not in the correct form, or not, maybe eliciting hearsay, and whatever it is, the jury is going to be instructed the proper elements. And so, as Judge Bandari said, have a little patience. It's just not a good look for you to be arguing with self-represented people who are going to lose their case anyway. So.
And one point that I would add to that is almost always we're obviously aware of that. So in my case, I would just say, okay, Mr. or Miss so-and-so, let's just move this along. You know, so a lot of times we're going to say something to address it anyway. And, you know, obviously if you have to object, you know, for the record on a substantive issue, then you're going to do it, but be strategic about it.
Right. I look at it like this. The pro se litigant, 9 times out of 10, will never get it perfect. They'll never get it to an attorney level. So sometimes, like the judges said, you have to give them a little bit of leeway so they can feel like they had their day in court. Alternatively, we shut down everything that they're doing because it's not perfect. You'll end up with an appeal for no reason, right? In my courtroom, I find that most of the self-represented litigants they may not be happy when they leave, but they are satisfied because they've had their day in court. They know that they've been heard. And I try to explain to them, even if an attorney objects, I'll usually explain the objection and why they can't say what they're saying, depending on what it is. But typically, I let them get their story out. And sometimes at the end, they're like, Judge, I know I owe the money, but this is when to tell me their story.
Well, thank you. That's good. It sounds like there needs to be a balance. You know, as attorneys, we want the rules of evidence to be followed. We want proper procedure. But yeah, at the same time, if, you know, we may have a jury watching us and it doesn't do our case any good to be, you know, antagonistic or, you know, create drama. So thank you for that. I think we are at the end of our time. I want to thank everybody for being here today, and I want to thank our panel of judges for taking the time to meet with us. Thank you, everyone. And again, if you registered, you will get your CLE credit. There is a poll that we would ask you to take regarding the CLE and how you felt it, you know, assisted you in your practice and knowledge. So if you have time to take that, we would appreciate it. So thank you, everyone.
I want to thank our amazing moderator, Smith Spencer, who took time to get this thing done. And really, thank you, Smith, for your hard work in today.
Thank you.
Preparing for this.
Thank you.